Hello, everybody. Thank you for joining us today. I appreciate your attendance. This afternoon's webinar will be from 1 p.m. to 2:30. The agenda is before you. I will provide welcome remarks, followed by licensing process clarifications by our Assistant Executive Director, Jason Killeen, followed by enforcement and compliance procedures from our Enforcement and Compliance Manager, Rocky Wiles, followed by questions and answers submitted by today's attendees. Next. I'd like to thank everybody for joining today and welcome to our licensing webinar. As you know, Kat Packer, our founding executive director, has left DCR after serving in her role for almost 5 years. Under her leadership, she oversaw 3 phases of licensing, resulting in the issuance of more than 350 licenses to social equity applicants and 1,250 licenses in total. We are thankful for her service, hope to continue her legacy in centering equity in our licensing and programming, and can't wait to see what she does next. I'm excited to step into this new role as acting executive director, and I look forward to our continued work and progress with our elected officials and stakeholders to improve our processes while placing equity, customer service, and expediency front and center. In continuation of Kat's legacy and abiding by the expectation of our elected officials and, most importantly, stakeholders, in 2022, DCR will focus on striving to reach the following goals: updating our licensing processes based on the recently proposed draft ordinance and updated rules and regulations which will be discussed at length today. Transitioning existing licensees into the environmental review process so the department may administer the annual licensure process later this year. Expediting the review and issuance of temporary approval to eligible applicants. Expanding the DCR licensing portal and updating the website based on proposed ordinance changes and forthcoming and expected changes as needed. Developing and opening the social equity individual applicant verification process, which is a prerequisite to the Phase 3 Retail Round 2 lottery. Opening up the Phase 2 Retail Round 2 lottery in early 2023, following a successful verification process. Advocating for our 2022 and 2023 budget asks, which include increased funding for social equity programming, citywide enforcement efforts, as well as the approval of 21 new positions department-wide to effectuate updated processes outlined in the recent draft ordinance, and continuing to roll out BLC programming, as well as much needed assistance to our current equity licensees, applicants, and prospective applicants. Improving and centering customer services for current licensees, applicants, and prospective applicants in whatever we do. Building out the department's enforcement and compliance unit to ensure accountability among licensees. Working with City Family to hopefully fund and formalize a streamlined process for unlicensed cannabis activity. I thank you in advance for your support and look forward to our collaborative work together this year. This webinar is streaming live on our website as we speak and will be recorded and available on our website for future reference. Moreover, the department plans on conducting another webinar very soon to further discuss the proposed rules and regulations following Council's action on this item. Please join our listserv on our website to receive updates about future events and announcements. Again, we thank attendees for submitting questions in advance for consideration. Immediately following the presentation, the department will spend some time answering as many questions as possible. Please stick around till the end. And now I'd like to kick it over to Jason Killeen, our Assistant Executive Director, who will discuss upcoming licensing changes, who will be followed by Rocky Wiles, our Enforcement and Compliance Manager, to discuss updates to our enforcement compliance program. Jason.
Thank you. This is Jason Killeen with the Department of Cannabis Regulation. I'm the Assistant Executive Director, which oversees the department's licensing programs. Next slide, please. During today's presentation, we're going to provide a summary of the proposed ordinance amendments It's important for our stakeholders to understand that these are still proposed ordinance amendments. We anticipate that the City Council will take up these proposed amendments next month. But until the council has adopted them and they've been approved by the mayor, these ordinance amendments will not go into effect. Our coverage today will include the amendments to definitions of owner and primary personnel, clarifications to when an application or a modification request may be abandoned, the creation of a refiling process, establishment of processing timelines to ensure both applicants and DCR move applications towards licensure in a timely manner. The proposed amendments clarify the successor in interest or surviving spouse provisions, which are located within the Social Equity Program, which is LAMC 10420. And the proposed ordinance also creates a standalone social equity applicant entity verification process that may be utilized to allow business entities to be verified prior to the submission of a temporary approval application. Next slide, please. We'll also cover a high-level overview of the updates to our proposed rules and regulations, which will be needed to implement the proposed ordinance changes. Our goal is to align the rules and regulations with our current licensing processes, as well as to create uniformity with the municipal code and or the state's licensing regulations. We've added new list of required information, forms, and documents for each stage of the licensing process. DCR will be hosting a future webinar to cover the required information, forms, and documents if the changes are adopted. The rules and regulations would reorganize operational requirements to consolidate and clarify different requirements for applicants and licensees. We've added some of the commonly used terms located on DCR forms, as well as other sections of the municipal code. And then we clarify the notice of violation procedures. Next slide, please. One of the first changes to the proposed ordinance is associated with the definition of owner. Currently, the city's definition relies on the state's definition, which has evolved over time. And as the state has updated their definition of owner, their definition has basically taken on what DCR recognizes and the city recognizes as being a traditional owner and conflated it with what the city refers to as primary personnel. So by having a standalone definition, we will, when we say owner, we will mean owner. An owner will mean a person, whether that's a natural person or an entity, with at least a 20% aggregate ownership stake or equity interest in the applicant or licensee. Aggregate means the total ownership interest held individually or through an entity. So for an example, an individual who owns 50% of an entity that owns 50% of a cannabis business would have a 25% aggregate ownership interest in the cannabis business. The ownership and financial disclosure form that applicants currently fill out allow the applicants to identify who are the owners and how they maintain their ownership through different levels between the applicant or licensee and the natural people who own the applicant or not licensee. Next slide, please. The next update is to our definition of primary personnel. Primary personnel is a natural person with at least a 20% aggregate ownership stake or equity interest in the person applying for a license or a licensee. A natural person who manages, directs, or controls the operations of the commercial cannabis business. If the applicant or licensee is owned in whole or in part by an entity, and the entity includes natural persons who manage, direct, or control the operations of the applicant or licensee, those natural persons shall also be disclosed as primary personnel. And DCR may determine in its sole discretion and on a case-by-case basis that additional natural persons have the ability to manage, direct, or control commercial cannabis businesses and or meet the criteria of primary personnel. This last piece is added because the state is undergoing changes. And in order for us to align our local regulations and process with the state's process, we may have to, from time to time, recognize other people that the state recognizes as primary personnel before the city is in a position to update the ordinance to realign with the state's definition. Next slide, please. Just to add a little context to the definition of primary personnel are always natural persons. A limited liability company, corporation, or other entity that is not a natural person is never a primary personnel. Additionally, a natural person with at least a 20% aggregate ownership stake or equity interest in the person applying for the license or the licensee is both an owner and a primary personnel. So when completing our ownership forms, you'll see two checkboxes. One is for owners, one is for primary personnel. You can select both boxes if a person meets the requirements for both owner and primary personnel. Next slide, please. Next, I'm just going to go through some of the general information associated with the proposed ordinance. First, all required information forms and/or documents need to be submitted through the DCR licensing portal at the time a record is created and submitted to the DCR. We've talked about this previously during webinars. The department does not accept placeholder documents. In order to navigate through our licensing process, whether it's pre-application review, the temporary approval process, or the environmental review process that will be opening up next month, you must submit all of the required documents or forms, or DCR will not be able to process the request. If information is not submitted, it may result in the abandonment of the record. If DCR requests for any reason additional information, forms, or documents, whether it's because the information provided was incomplete or because DCR needs additional information to make a determination, applicants have 30 days to provide everything through the DCR licensing portal and pay any applicable fees. Unless another period of time is specified in writing by DCR, 30 days is the default for folks to submit additional information to the department. And the last piece is DCR does not refund fees for an abandoned application or modification request. Next slide, please. Moving on to the pre-application review process. The proposed ordinance would require DCR to complete its review of the pre-application review record within 30 days of the date the pre-application review fee is paid. Once submitted, record data may not be amended. Once the fee is paid, DCR staff will go into the record and begin our review. If we do not have the landowner attestation form on the record when we begin our review, the record is ineligible for further processing and will be closed out. The pre-application review process is site-specific. The eligibility determination made for the address listed on the record is not eligible to be transferred to either an expanded site or to another location. If you are unable to move forward at the proposed business premises address, you will have to submit a new pre-application review record so that we can conduct a land use review of that new proposed business premises location. And again, pre-application review records may not be amended. So once you've entered an address, that record is locked into that address. Next slide, please. In regards to the temporary approval application process, the proposed ordinance would require DCR to complete its review of the application record within 60 days. If all information, forms, and documents are in correct form and manner, the record will receive a status of local compliance underway. As stakeholders know, this is the status that folks who are also applying for state licenses want to reach, because DCR will report a status of local compliance underway to the state agencies, which enable the state agencies to issue a provisional license. If the application is incomplete, the record will receive a status of additional info needed. Processing of the application shall be suspended until the application has been corrected. Again, the applicant will have 30 days to pay applicable re-review fees and to submit the missing information, documents, or forms to the department to get to a complete application. If the record is still incomplete after the second review, it shall be deemed abandoned. The proposed ordinance holds DCR accountable for ensuring that records are processed in a timely manner within the context of the code. And if the record cannot be processed within that defined term, it will be deemed abandoned if there are deficiencies. Next slide, please. Temporary approval application records with the status of local compliance underway may request an initial inspection. The proposed ordinance would require a DCR to schedule that inspection within 45 days of the request. Typically, DCR is able to accommodate initial inspections within 15 days of the request coming in. When folks submit their initial inspection requests, we do ask for them to provide 3 different dates and times that they can work with, and DCR will most likely be able to accommodate one of those dates and or times. The assigned licensing analyst will now start to conduct the equity share review, if applicable, of course. Previously, the equity share review was being overseen by the social equity group. In order to ensure that we have capacity to conduct the equity share review in a timely manner, DCR will be delegating this to the licensing analyst assigned to do the temporary approval application review. The equity share team will be available to provide oversight over the program, as well as insight if an analyst has questions, but the licensing analyst assigned to the record will begin doing the equity share review beginning in April. Within 15 days of completing the equity share review, if applicable, or passing an initial inspection, whichever occurs last, DCR will update the temporary approval application record to a status of temporarily approved and notify the applicant. This is the stage at which the applicant has received a provisional or temporary license from the City of Los Angeles. In order to begin operating, the applicant will also need to have a corresponding provisional license issued by the state and meet all other requirements, whether it's health permit requirements, building code requirements, fire code requirements, in order to operate. Next slide, please. Once a business has received temporary approval, they're eligible to transition into the environmental review. The pre-application review and temporary approval application processes make up an applicant's draft project description. For records that have received at least a status of local compliance underway, the department has been reporting to the state that the project description is under review and CEQA compliance is underway. Once the temporary approval process has been completed, an applicant is able to move into the final project description and environmental review necessary to transition to an annual application. For businesses that do have temporary approval, they will be able to begin filing their final project descriptions in April. DCR has consulted with multiple environmental lawyers on this issue, and we have determined that the state's project description form is sufficient for the city's needs. Therefore, DCR will be accepting final project descriptions on the state's project description form. an email communication will be sent to applicants with temporary approval so that they understand what forms can be submitted and how to initiate this process. The city received a $22 million grant from the state of California to assist our licensees in transitioning to annual licenses. The city is utilizing those funds to provide fee waivers for the basic environmental analysis as well as the annual application fee. These fee waivers will be provided on a first come, first served basis until the monies have been fully exhausted. We have about half of the money available to assist with the annual application fees, and then the other half will go towards the environmental review fees. The environmental review fee is site specific, and one fee is paid regardless of the number of activities associated with that record at that location. Of course, the annual application fees are charged per activity and will be due per activity. In order for DCR to move a licensee to the annual application process, they must complete the environmental review, and we must deem the application complete. So as we start to transition people through the environmental review and we start to deem records complete, we will be providing additional webinars to provide folks information on how to move forward after the environmental review process. Next slide, please. To kind of explain how the department will be conducting this environmental analysis, we put together this slide. DCR is authorized to use the Department of City Planning's internal environmental consultant list. DCR had done a procurement process, or the city planning had done a procurement process to identify environmental consultants that can look at different land use projects. We've worked with the Office of the City Attorney and City Planning to determine that their consultants have the capacity and the expertise to assist DCR in conducting these environmental reviews. We will begin collecting final project descriptions in April. DCR plans to bundle these project descriptions for environmental review. We will be issuing requests for bids to allow project descriptions. Authorized consultants will have 4 to 6 weeks to respond to the RFP or request for bid. DCR and issue notices to proceed. Consultants will then analyze final project descriptions and assist DCR with the findings. This process will begin in April. We anticipate that consultants will be conducting the review of the final project descriptions in late June or early July, and we will complete the environmental review on individual records on a rolling basis. Next slide, please. The next big modification, or the next big proposed change, is associated with the application modification process. As I stated earlier, the business premises location deemed eligible for further processing through the pre-application review process cannot be amended while the associated temporary approval application is pending. Only licensees are able to submit relocation modification requests. However, applicants may submit other modification requests through the DCR licensing portal for a period of 60 days after the submission of their temporary approval application record to amend information, forms, and/or documents submitted as part of that record, subject to the payment of any required modification fees. The 60-day clock will begin the date you hit submit, and the record is created within the DCR licensing portal. Payment of the fees are not required prior to the initiation of the 60-day clock. So if you submit your record and you immediately realize that you uploaded the wrong form, your status of waiting for payment would allow you to go in and add the missing documents and or provide DCR the corrected documents so that once your fees are paid, we can begin our review and you've already addressed a deficiency that may have existed. That is a deviation from our existing process because currently, once a record had been submitted, no changes were allowed until one, the fee was paid, and two, DCR began its review. So we've already updated the portal to allow applicants and licensees to upload additional information if their record status is waiting for payment, so that folks who know that they have made a mistake upon submission have the opportunity to immediately go in and correct that mistake without incurring additional fees and before DCR has begun its review. If you do have to submit a modification request, application processing shall be suspended during that modification process. So we will not be processing your temporary approval application in parallel with the consideration of the modification request. Next slide, please. The types of modification requests will be listed within the rules and regulations. Basically, folks will have an opportunity to submit any modification request other than a relocation modification request during the first 60 days. For modification requests that result in the issuance of a new temporary approval record, DCR will only be creating new temporary approval records for entity substitutions or 100% ownership changes. And one of the common questions that we've been working with stakeholders on is the easiest way to know whether or not it would be considered a 100% ownership change is to look at the level 1 owners on your hierarchy of ownership. And if 100% of the level 1 owners are changing, it will be considered a 100% ownership change, regardless of whether or not an existing owner is being moved to another level, or they will be an owner of a new entity that is an owner of the applicant or licensee. Next slide, please. In terms of license modifications, so once temporary approval has been issued, the business has a provisional license or a temporary license to operate. At that time, in addition to the modification requests that an applicant may submit during their first 60 days, they have the ability to submit relocation requests. Certain license types, specifically retail storefront and cultivation, may only be relocated within the community plan area the license was issued for. The proposed ordinance does not change the limitation on what relocation requests DCR has the ability to consider and process. DCR did propose an amendment that would have allowed retail and cultivation licenses to be relocated to a community plan area that had not reached undue concentration. The city council did not adopt that recommendation. That the proposed language is not included in the proposed ordinance. So if it is adopted, folks are still limited for retail and cultivation license types to the community plan area that the license was authorized in. DCR will be reporting back to the Planning and Land Use Management Committee with additional information associated with that recommendation, and the City Council may consider future amendments at a later date. Next slide, please. As it relates to abandoned records, for pre-application review records, a pre-application review record that is deemed eligible for further processing must be converted to a temporary approval application or annual application record within 1 calendar year. If the pre-application review record is not transitioned to a complete application within 1 year, the pre-application review record will be deemed abandoned. For temporary approval applications deemed abandoned after January 1st of 2022 may have the ability to refile an application subject to the requirements listed in the municipal code. Again, refiling would be created if the proposed ordinance is adopted. Currently, the city does not have a refiling process. Similar to the limitation on relocations, a refiled application may only be considered within the community plan area that the temporary approval application was refiled. So if you applied for retail storefront or cultivation and that record is deemed abandoned, you will not be able to refile it in another community plan area. Next slide, please. The refiling process will be initiated through the DCR licensing portal, and it may be initiated within 1 calendar year of the date DCR notifies the applicant by electronic mail that the original temporary approval application is deemed abandoned. Since this process doesn't currently exist, for folks that were deemed abandoned between January 1st, 2022, and if adopted the date the ordinance becomes effective, we will send an email communication letting them know that their record status has been updated to allow them to activate the refiling functionality. If your record is deemed abandoned and it is eligible for refiling, under the action requested or required section of the DCR licensing portal, you will be able to click on the action required to initiate the refiling. This process is similar to how folks submit their renewal request to the department, that during the renewal phase, an action required button will pop up next to the corresponding record. And by clicking on that button, it will immediately drop the requester into the associated application record. Same thing will happen for abandoned records. If you click on the action required button, it will take you into the beginning of the pre-application review process to start the refiling process. All refiled records will be required to go through a new pre-application review process. If DCR determines that the proposed business premises location is ineligible for further processing, so you would not be able to move forward, you will be able to reinitiate the refiling process at a different proposed business premises location, provided that the new record is submitted within the original 1 calendar year timeframe of the original temporary approval record being deemed abandoned. So if you act early, you may have multiple bites at the apple and an opportunity to vet multiple business premises locations prior to the refiling period expiring. Next slide, please. The refiled record may not seek authorization to conduct any commercial cannabis activities that are not listed on the original temporary approval application, or to seek a proposed business premises outside of the community plan area listed on their original temporary approval application. So what this means is, if you initially applied for cultivation and distribution, when you refile, you have the ability to apply for cultivation or distribution. Similar to the way the renewal process works, the default record will include both activities that were listed on the original record. You could proceed with moving forward with both, or you can unselect activities if you don't want to move forward with those activities anymore. Also, if the application is subject to a finding of public convenience or necessity, that PCN finding is site specific. Therefore, a refiled application must be submitted for the same proposed business premises location. The last point I want to make is refiled applications are not subject to a finding of undue concentration. So if you are a phase 2 applicant who had requested cultivation in a community plan area, and your record is deemed abandoned, and you refile within 1 calendar year, regardless of whether or not that community plan area had reached undue concentration for cultivation, DCR will have the authority to process your temporary approval application. It is important for folks to understand that if you have an application pending in an area, regardless of whether or not the area is currently subject to a finding of undue concentration, if you are abandoned and you do refile, the temporary approval application that would be associated with that refiling would not be subject to a finding of undue concentration. And the last piece is a refiled temporary approval application that is later deemed abandoned for any reason may not be refiled again. Next slide, please. As I mentioned earlier, temporary approval applications abandoned for any reason prior to January 1st, 2022 may not be refiled. Temporary approval applications previously denied by operational law, or deemed ineligible for further processing may not be refiled. Temporary approval applications and social equity temporary approval applications with more than one social equity individual applicant listed to meet the equity share requirements on the initial temporary approval application may only refile the application under the original entity. Since the city does not currently allow more than one social equity individual applicant to meet the social equity requirements under 10420, that entire last piece is a moot point right now, but it may come into effect at a later date if the city council adopts a future amendment to allow multiple SEIAs to meet the equity share requirements. So the proposed ordinance kind of future-proofs council's ability to consider allowing for more than one social equity individual applicant to meet equity share requirements under 10420. All of our existing social equity temporary approval applications have one qualifying social equity individual applicant. That is the social equity individual applicant who is identified to meet the equity share requirements under 10420. If a social equity temporary approval application is deemed abandoned, the social equity individual applicant may refile that record under a new entity, or they may refile it under their original entity. Next slide, please. The proposed ordinance also outlines a few of the timelines associated with DCR's administration of phase 3 retail round 2. In order to implement phase 3 retail round 2, the department is required to open up another social equity individual applicant verification process. DCR is required to have a 60-day eligibility verification period where natural people will be able to be verified under the revised eligibility requirements. The key piece there is individual eligibility verification is tied to a natural person. DCR does not vet entities as social equity individual applicants. The social equity applicant would go through an equity share review, which is unrelated to the actual verification for individuals. DCR will have at least 90 calendar days to process all eligibility verification requests that are submitted during that 60-day period. The 90-day eligibility verification period DCR has will not run concurrently with the 60-day period. So whatever gets submitted during the 60-day period will be reviewed after the 60-day period closes. DCR is guaranteed at least 90 calendar days to conclude processing those eligibility verification requests. Depending on how many requests are submitted, DCR may need additional time, and the code allows DCR additional time if necessary. Our goal would be able to complete our processing within that 90 calendar day period. And hopefully the additional positions that have been approved by the mayor and council recently will go a long ways to ensuring that we are able to process it within that 90 calendar day period. Once we have processed all of the eligibility verification requests, DCR will begin accepting registrations for the Phase 3 Retail Round 2 application lottery. DCR will accept registrations for a period of 30 days from verified social equity individual applicants. If you have not been verified under the revised eligibility requirements, you will not be able to submit a registration to participate in the Phase 3 Retail Round 2 lottery. Only verified social equity individual applicants will be entered into the application lottery. So once we've opened up the registration period, we've vetted the registrations to ensure that they're only associated with verified social equity individual applicants, DCR will determine the date of the lottery. And DCR is required to post notice at least 15 calendar days prior to the administration of the lottery. Next slide, please. Transitioning to one of the key components that social equity individual applicants had commented on is successors. Under the current ordinance, there are limitations as it relates to how long a record can be considered social equity upon the death of the social equity individual applicant. The proposed ordinance would make significant amendments to ensure that a record could continue to be considered social equity even after the death or incapacity of a social equity individual applicant. So as stakeholders know, equity share shall not be subject to arrangements causing or individual applicant for their equity share, other than after death or incapacity. The proposed change would allow for the social equity individual applicant successor, it's a surviving spouse or successor in interest of the deceased, to inherit or otherwise acquire all of the social equity individual applicant's ownership interests in the social equity applicant or licensee. So basically, if the social equity individual applicant were to pass away, they would be able to transfer their equity ownership to either their surviving spouse or a successor in interest. And even if that successor is not a social equity individual applicant themselves, the record can still be considered a social equity record, provided that individual can maintain the minimum equity share as provided by 10420. Next slide, please. Now I'm going to briefly transition into state deadlines. I just want to remind stakeholders that DCR has no authority to administer the state's licensing process, nor do we have any authority to override any of the state's processes or deadlines. One of the deadlines we've been getting a lot of questions about is associated with the March 1st, 2022 deadline. This is a deadline set by the state for applicants to submit an application to be considered for a provisional license. The state has two carve-outs. One of the carve-outs is for certain cultivation applicants, and the other carve-out is for local equity applicants. Social equity applicants, subject to the equity share provisions in 10420, Phase 2 Tier 1 applicants, which are also subject to equity share review, and Phase 2 Tier 2 applicants, which are also subject to equity share review, are considered local equity applicants. Phase 2 Tier 3 applicants are not considered local equity applicants. Tier 3 applicants do not go through an equity share review. In order to get priority processing, a Tier 3 applicant will enter into a social equity agreement with the city to provide benefits to bona fide social equity applicants. Tier 3 applicants are not considered local equity applicants. At the state level, they are currently considered general applicants. In terms of June 30th, that is the last day for the state's Department of Cannabis Control to issue provisional licenses for all license types, including licenses resulting in the equivalent of the large cultivation license. The city does not accept applications, nor is it issuing large cultivation licenses. So we don't have any type 5, 5A, or 5B license types that are pending in our application queue. And then the same carve out that applied to the March 31st date applies to the June 30th date. Certain cultivation applicants, medium indoor and below at the local level, and local equity applicants are not subject to the June 30th deadline. Next slide, please. The deadline for certain cultivation applications to get submitted is June 30th. Beginning July 1st, provisional license are going to be subject to specified conditions. DCR will begin issuing letters to businesses with temporary approval stating that their CEQA document has a status of project description underway or under review, and CEQA compliance is underway next month. That document can be used to satisfy the new condition for the renewal of a provisional license with the state of California. So you will need a document from the local agency, which is the city, to verify that your project description is under review and CEQA compliance is underway in order to renew a provisional license after July 1st. For September 30th, 2022, that is the last for the Department of Cannabis Control to issue provisional licenses for certain cultivation applicants. Next slide, please. March 31st, 2023 is the deadline for local equity applicants to submit an application to be considered for a provisional license. June 30th of 2023 is the last day for the Department of Cannabis Control to issue provisional licenses to local equity applicants. Our social equity applicants have a different deadline than general applicants. So please be advised that local equity applicants, or what the city refers to as social equity applicants, have an additional year to seek an initial provisional license from the Department of Cannabis Control. Beginning in July 1st, 2023, in order to renew a provisional license, the state will have additional requirements. DCR will do its best to ensure that our licensees are positioned to renew their state provisional licenses. January 1st of 2025 is the last day for the Department of Cannabis Control to renew a provisional license. After January 1st, 2025, the state will no longer accept renewal applications for provisional licenses, nor will they issue new provisional licenses. Therefore, in order to continue operating after January 1st, 2025, a licensee may need to have an annual city license and an annual state license. Each business at the state level has a unique expiration date. So if your final provisional license will expire after January 1st of 2025, you will need to ensure that you have secured an annual city license, because an annual city license and the corresponding environmental analysis document that was adopted as part of that annual process will be required for you to have a complete state annual application. And then, of course, if the state is not issuing new provisional licenses after January 1st of 2025, there won't be any provisional licenses in effect beginning January 1st of 2026. Next slide, please. And now I will turn the presentation over to Rocky Wiles.
Good afternoon. I don't know if anybody can see me. My name is Rocky Wiles. I am the manager over the department's Compliance, Enforcement, and Operations Division. This is a new division in the department, and we have recently begun to bring in and train a compliance team, which is currently 2 full-time staff and 2 part-time staff. But we hope to add about 5 or 6 new members in the next couple of months. Next slide, please. This compliance team manages the complaints received by the department, primarily via the complaint portal. When a determination is made that the complaint is 1, cannabis related, and 2, violates 1 or more of the operational regulations, we will briefly go over this afternoon. We will then investigate the complaint and take appropriate action. We also work with other agencies which handle enforcement functions to verify authorized versus illegal commercial cannabis activity. The department intends to implement a proactive and progressive strategy where the compliance team will be reaching out to our operators to make sure that they are aware of the operational requirements dictated by the Cannabis Procedures Ordinance and by the rules and regulations. We will be contacting businesses which are subject of a complaint received by DCR, give them the opportunity to correct any potential violations. We may visit locations to verify compliance. And if after all these efforts, we determine that the violation has not been corrected, we may issue a notice of violation which will carry penalty fees. Please note that once the NOV becomes final and effective, you will receive an invoice for non-compliance fees. These fees cannot be waived or reduced. Next slide, please. So compliance and enforcement rules are compliance and enforcement rules are regulations are contained in regulations 5 and 6. Regulation 5 are the operational requirements and violations. Regulation number 6 pertains to administrative violations, penalties, and appeals. I will summarize the updates that were made to the operational requirements and violations, which is regulation number 5. Note that this was formerly regulation 10, We consolidated and clarified operational requirements. We eliminated redundant regulations. We eliminated regulations already handled by the State Department of Cannabis Control. We reorganized regulations to reconcile the city's requirements with the state's amended regulations. Next slide, please. So quickly going over the organization of regulation number 5, we basically divided it into 6 sections, which is A through F, starting with the general requirements in regulation 5A. Subsections in the general requirements, just so you can get an idea of what how we categorize them, are starting with the responsible management requirements, followed by responsible management of the business premises, then unauthorized modifications, security measures, business premises equipment. Then there are regulations about prohibited activities, and finally required notifications. Next slide, please. 5 remaining sections in regulation number 5 pertain to record requirements, which is regulation 5B, retailer commercial cannabis activity, which is 5C, delivery commercial cannabis activity, which is regulation 5D, micro business commercial cannabis activity, which is regulation 5E, and finally the testing commercial cannabis activity, which is regulation 5F. And there are subsections within each of these sections. Next slide, please. Now, to summarize the updates that we made to regulation number 7, which is the administrative violations, penalties, and appeals. First, was renumbered. Formerly, this was regulation number 11. Now it's regulation number 7. So DCR is the lead agency for enforcement investigations and actions related to commercial cannabis activity. We add a subsection entitled Notices of Violation, and this is to provide clarity related to compliance. For example, timelines to comply, extensions of time, due dates for administrative penalties. This was not in the regulations before. And we kept subsection related to administrative appeals. We made non-substantive edits just for clarity. Next slide, please. As with the previous version of the rules and regulations, specifically regulation 10, at the end of each regulation, we have included the grade or the severity if the regulation is violated. This is indicated in parentheses in each of those regulations under regulation number 5 now. However, the regulations do allow the department to downgrade or upgrade the severity of the violation if the department determines that it's justified. For example, if there are repeated violations, we may upgrade the severity of the violation. Types of violations and the respective penalties are in section 104.19I, which is fines, violations, and non-compliance fees. This did not change, but I just wanted to point these out. Violation types and the penalty for each regulation are up on the screen. So you'll see that the minor violation is $7,004. For a moderate violation, that would be $21,013, and a major violation would cost $42,000 with $42,026. So to conclude, and this is, by the way, this is for each violation of the regulations. So to conclude, I just want to reemphasize that the department will be reaching out to each and every one of our licensees to make sure that you have a copy or a link to the rules or regulations as soon as they are adopted and approved by council. The operator will be required to sign an attestation which states that they have read regulation number 5 and agreed to abide by it. Our compliance team will be reaching out to each of our licensees and may stop by to answer any compliance-related questions and to collect the attestation form. We will communicate with our licensees after these regulations, like I mentioned, have been adopted by council, so nothing is a surprise to you. We want to build good relationships with our licensees in the communities where they're operating by providing education related to compliance. So lastly, we appreciate your patience during the implementation of this new function, and we look forward to working with you all. I'm going to pass it over to Jason. Thank you.
Hi, everybody. I'm just going to chime in. This is Michelle Barakian, the Acting Executive Director. We're going to move into question and answer portion of this webinar. I thank you to the team for presenting today. Also, there are a bunch of folks who remitted questions beforehand and folks who provided some questions in our chat this afternoon. We've done our best to incorporate all of those questions. At this time, I'm going to hand it over to Olivia from our team to ask those questions, and Jason and or Rocky will providing answers. We'll be with you until 2:30 p.m. today, and I'll see you in a little bit. Olivia?
Thanks, Michelle. Our first question is from Chelsea P. Will these slides be available on the DCR website?
Yes, the slides along with a recording of the webinar will be available on the DCR website.
Great. Our next question is from Jeff K. For provisional LA licensees, how do they convert their provisional license to an annual license? Is it automatically through renewal, or do they have to submit a separate annual license application? If they need to submit a separate annual license application, when is the earliest that a provisional licensee can submit such an annual license application?
Okay, that was a lot. I will do my best to answer all of it. At the local level, a provisional license is considered a temporary license or temporary approval. Businesses that have received temporary approval are eligible to submit their final project description. That is the project description that DCR will utilize for its environmental review. The business must complete the environmental review process before they are eligible to submit their annual application. Once they've completed their environmental review, any documentation that may not be on the record already that is required for the record to reach a status of complete will be accepted. Once we have deemed the record complete, we will issue an invoice for the annual application fees. The record itself within our workflow naturally transitions between the milestones. So businesses that have temporary approval will be able to transition into the environmental review, the submission of their final project description, and then payment of any applicable fees will enable them to move through that portion of the workflow. Once the analysis is completed, DCR will re-review the record to determine if any additional information is needed to reach a status of complete application. If we need additional information, we'll reach out and ask for it. The applicant will have 30 days to get it to us. If we don't need any additional information, DCR has the ability to deem the record complete. Once we've deemed it complete, we will issue the invoice for the annual application fees. And then, of course, once the fees are paid, DCR will begin the annual application processing for that particular record. So hopefully I hit all of those points.
Yes.
And sorry, the earliest somebody will be able to transition to the annual application process will likely be late summer after we've completed the environmental review of their existing temporary approval record.
Great, thank you. The next question is from Harry. What are the revised eligibility requirements for social equity applicants?
The requirements themselves are similar to the original requirements. You can qualify based on having low income, having a prior commercial cannabis related arrest or conviction, or living in a disproportionately impacted area. Under the new requirements, you have to have 2 out of the 3, and it can be any 2 out of the 3, which is a deviation from the original requirements. For the residency component, it has to be 10 years of cumulative residency in a disproportionately impacted area. And the disproportionately impacted areas are defined by the police reporting districts that are identified within the rules and regs. So DCR has prepared a verification intake form where folks will be able to answer questions and upload corresponding information to demonstrate that they meet the requirements to become a verified social equity individual applicant.
Great. Our next question is from Lauren A. I would like to submit an application to add a new activity to an existing entity. Is this considered a modification? How do I go about doing this?
That is not considered a modification. DCR does not allow businesses to add activities to existing records. In order to add an activity, the requester will need to submit a new pre-application review record. DCR will review it for land use compliance and eligibility. And if it's eligible for further processing, then a temporary approval application can be submitted for that activity.
Okay, our next question is from Nayruth B, M Gastelum, and Gloria. Will the new ordinance allow for the relocation of commercial cannabis activities subject to undue concentration outside of the original community plan area?
No. The proposed ordinance does not amend the existing restrictions associated with relocation modification request. DCR will be preparing a report to the Plum Committee regarding a future amendment addressing relocations, possibly outside of the community plan area.
Our next question from Maggie Yu. When attempting to begin a pre-application for a micro business, will I have to apply individually for each activity and pay separately for each permit? Or by applying for a micro business, will it incur one fee for the multiple activities?
At the local level, applicants must apply for each activity and pay the associated application fees for each activity.
Okay. Our next question from Artur H. I would like to apply for a delivery license under the social equity program and would like to know how far away the address I would like to do business from should be from a church and a school.
For
For a
delivery-only license types, the proposed business premises location must be located at least 600 feet away from a school. Non-storefront delivery licenses are not subject to any other buffering from sensitive uses other than schools. Religious institutions such as a church are not considered a sensitive use by the City of Los Angeles.
Okay, a follow-up question. When will the storefront retail licenses open for new applications with the social equity program?
Whatever retail storefront capacity exists at the time DCR opens up a lottery will be available through the lottery as part of phase 3 retail round 2. If additional retail storefront capacity exists after we administer the first lottery for round 2, DCR has the authority to administer additional lotteries until undue concentration has been reached citywide.
Thank you. And if I apply and get a delivery license, can I apply for a storefront retail license after that?
Yes. Businesses can hold both a delivery and a storefront retail license at the same location, provided that each license has its own defined business premises diagram. And if you get a delivery license, that activity is also authorized under a full retail storefront license. So you may not have to renew your delivery license after you've received a retail storefront license.
Okay. Do current social equity program applicants have to recertify? And what license types are they eligible for? And will all the licenses be awarded through a lottery process?
Applicants seeking to participate in phase 3 retail round 2 will need to be verified through the re-administered process.
Okay.
For, I would refer folks back to the municipal code section 10420, which identifies which type of social equity individual applicants can apply for which type of licenses. As folks know, people who have already been verified can apply for non-storefront delivery, manufacturing, distribution, any of the license types that are currently available. And then, of course, folks that get verified under the new process will have the ability to participate in retail storefront or phase 3 retail round 2. So only those folks would have the ability to pursue a retail storefront license through that process. Folks that have already been verified do have the ability to submit a PCN request for the retail storefront activity for areas that have reached undue concentration.
Okay, another question from Yelena K. When should existing licensees start submitting the DCC project description form? And should this be uploaded to the application record? Will there be a separate set of instructions / document requirements for annual applications?
I'll do my best to answer. Folks can start submitting a completed DCC project description form as soon as records are updated in the portal. First, DCR will issue the environmental letters that existing licensees will need to renew their state provisional license. When we roll that out, we'll also be rolling out the functionality to allow for people to supplement their record with their final project description. Once the project description has been analyzed and we've made a recommended finding, we will be doing a re-review of the record to determine if it's complete. If the record's not complete, then folks will be asked to submit additional information to get to a complete record. If it is complete, we'll issue a notice of complete application and invoice the business for their annual application fee. And because phase 1, phase 2, phase 3 all had different requirements, folks may get different information based on their phase to get to a complete record. The finish line for a complete record is the same regardless of phase. So certain businesses may need to submit different documents than people that are coming into the process today.
From Jesse F. When will the PCN portal reopen?
Unless the PCN process is further amended by policymakers, i.e. the city council and mayor, DCR anticipates opening the PCN process sometime later this year.
Question from Jack Z. Are applications for cultivation licenses being accepted for non-social equity applicants?
No, not at this time. Cultivation licenses are exclusively available for social equity applicants until January 1st of 2025. And DCR is not currently accepting cultivation applications from any applicant at this time.
Question from Nick S. and Chris. What date can we revet for phase 3?
The social equity individual applicant verification process will reopen before the start of phase 3 retail round 2. DCR will provide public notice as required by the code when we plan to reopen the verification period. And we anticipate that it's going to happen later this year.
From Tracy L, can you operate retail prior to environmental review approval?
If you have received a temporary approval for retail storefront by the city, you have a corresponding state provisional license, and you meet all other code requirements, then yes, you would be able to operate a retail storefront business prior to completing the environmental review process.
From Luis R, can you please clarify the rules and procedures regarding splitting the equity share requirements between two individual social equity applicants in order to meet the minimal equity share criteria?
Sure. Just to be clear, the proposed ordinance does not change existing law. So DCR recommended a modification to allow multiple social equity individual applicants to collectively meet the minimum equity share requirements within the code. That has not been approved by policymakers, nor is that change included in the proposed ordinance. Again, DCR will be reporting back to the Planning and Land Use Management Committee to provide further clarification on that issue. And we will hopefully be reporting back to the committee later this year.
From Angelo S, if our application was accepted, but our number was higher than the initial number of licenses that were granted, are we still on the list after all of the changes, or do we start over?
I don't know if I'm interpreting the question correctly, but if you participated in phase 3 retail round 1 and your record number is not one of the 200 records that were deemed eligible for further processing as allowed by code, you do not have an application pending before the department. And if you seek to pursue a commercial cannabis license, you will have to submit a new application, or you will actually have to submit an application in order to be considered for a commercial cannabis license.
Question from Gloria. Are phase 3 retail round 1 applicants able to change from tier 1 to tier 2?
Businesses that have received a license, regardless of whether it's phase 2, phase 3, have the ability to submit ownership modification request. When we review the ownership modification request, it will look to make sure that it complies with LAMC 10420. As long as the social equity individual applicant maintains the requisite equity share based on how they've been verified, there is the possibility for the record to have a social equity applicant that only has 33 1/3% equity in the applicant or licensee.
Question from Nick S. When will the lottery phase begin and how will it be conducted?
The lottery itself will not be conducted until 2023. In order for DCR to administer the lottery, first we have to administer a new social equity individual applicant verification process. And then DCR has a period of time to vet all of the verification requests submitted. That process will take at least 6 months, or sorry, at least 5 months to complete, and could take longer. And then once we've completed that process, we're required to accept registrations for participation in the lottery. And then we have to post notice of when the lottery will be held. So all things combined, it will probably take at least 6 or 7 months before we're in a position to administer the lottery.
Question from Angelo S. If we do have to start over, do we get any priority granted that we were already accepted?
No.
Okay, thank you. And you touched on this in your presentation, but a question from George D. What is the March 31st deadline?
The March 31st deadline is a state deadline for general applicants applying for anything other than cultivation to submit their application for a state provisional license. And then the Department of Cannabis Control has until June 30th to issue new provisional licenses. For businesses that are applying for a cultivation provisional license, there's a different deadline. And then local equity applicants have until March 31st of 2023 to submit their state provisional license for a new provisional license. You know, the caveat there is, of course, the city has no control over the state's process. And, you know, those dates may change based upon what the state decides to do, and we don't control that. So we provide the dates and kind of the information associated with the dates for informational purposes only.
Great. Thank you, Jason. That was the last question I had.
Thanks, Jason. Thanks, Rocky. Thanks, Olivia. Thanks to the staff that participated and helped organize today's webinar. I hope all of our attendees found this helpful. I am Michelle, and we look forward to working with all of you guys as the City Council considers these changes to our ordinance and updated rules and regs in the coming days. It is likely that we will be hosting an additional webinar the week of April 11th, where we will go into more detail about the rules and regulations that were briefly touched on today. As a reminder to all licensees, you will be receiving an email later this afternoon about good faith hiring requirements survey. We ask that you fill that out, as it will help us create programming that will assist you with reporting compliance. Thank you very much. We have recorded everybody's questions today. We received over 40 questions during this webinar, and approximately, I think, 30 or 40 prior to the webinar. We're going to get to the remaining questions that we didn't answer at another webinar. And I just want to say thanks, everybody, for participating. We look forward to working with you in the future, and I hope everybody has a wonderful day. Thank you.